todos e a todas e inicio a minha fala parabenizando a organização desse evento, que já participo há várias edições, e faço agradecimentos especiais ao professor Luiz Eduardo Schweire, ao professor Luiz Flávio Neto e ao professor Rodrigo Maisto, e também um agradecimento especial ao queridíssimo Dr. Ricardo Mariz de Oliveira, presidente do IBFD, que será o nosso homenageado no terceiro Congresso Pernambucano de Direito Tributário, que aconteceria em outubro desse ano, no próximo mês, mas que, em função justamente da pandemia, vai ficar para o ano que vem, mas vai ser com muita alegria que vamos homenagear o Dr. Ricardo. E mais um ano desse fantástico congresso. Me cabe, dessa vez, presidir a mesa e já apresento os palestrantes, com muita honra, o decano do painel, um dos ícones da tributação internacional, nosso querido professor Guglielmo Maisto, professor de International and Comparative Tax Law da Universidade Cattolica de Piacenza, na Itália, autor de diversos livros, diversos artigos e realmente um expoente do direito tributário internacional. A doutora Joanna Willer, que é PhD pela Universidade de Amsterdam, Senior Member of IBFD, também participou do subcomitê de pesquisa do International Fiscal Association, é palestrante convidada de universidades renomadas como a Universidade de Cambridge, Leiden e de Londres, professor Vikram, que é professor no Tax Policy Center da Universidade de Lausanne, na Suíça, o nosso brasileiro Alexandre Alkmin, que é doutor em Direito Tributário pela USP e pós-doutor pela Universidade de Santiago de Compostela, professor da Faculdade Milton Campos, diretor da ABRADT e advogado, e a doutora Marta Leão, doutora e mestra pela USP, com instâncias de pesquisa científica no Max Planck, é professora da Universidade Presbiteriana Mackezie, sócia do escritório de Humberto Ávila. E esse que vos fala é o professor André Dantas, da Faculdade de Direito do Recife, mestre em International Taxation pela Universidade de Leiden, doutor em Direito Tributário pela Universidade de Salamanca, Espanha, com sanduíche dos Estados Unidos, e auditor fiscal da Receita Federal. Bom, o tema que nos ocupa é um tema extremamente nobre e atual, o direito tributário internacional pós-Covid-19, um novo futuro. Observem, recentemente nós tivemos as conclusões do projeto BEPS e suas implementações. A comunidade internacional, os doutrinadores, pesquisadores, não têm uma opinião unânime, não tem uma uniformidade de pensamento, e isso é natural no mundo da pesquisa científica, e muitos desafios já se colocavam antes da pandemia. E agora nós estamos vivenciando um período extremamente delicado, assim como as empresas transnacionais se expandiram em sua corrida por novos mercados, determinando a atual etapa do modo de produção capitalista, a globalização. Nós estamos vivendo uma crise sanitária com consequências internacionais extremamente difíceis e que não temos respostas ainda para muitas de suas consequências. E aí eu faço a colocação que no mundo da tributação internacional isso não é diferente e a gente não pode responder com segurança a várias perguntas no ambiente do International Taxation, especialmente à luz de uma visão binária do mundo, daquilo que possa ser certo ou que possa ser errado. O mundo não funciona dessa forma. O mundo é um gradiente complexo, multifatorial, e uma visão binária dos problemas, da resolução desses problemas, pode conduzir a conclusões reducionistas e, portanto, equivocadas. A complexidade nos conduz, portanto, a conviver com inseguranças e incertezas. Nesse contexto, o nosso painel dividido em dois blocos vai tratar inicialmente das consequências da pandemia sobre o direito tributário internacional. E para iniciar essa fala, eu convido a doutora Joanna Willer.
Thank you, RJ. Thank you also to the organisers for inviting me to join this panel. I'm very happy to do so. And to all the participants, good morning, good afternoon, good evening, whichever suits you best. It's afternoon to me here in Amsterdam. So I will share my screen. There we go. And you should see the whole PowerPoint. Okay, so what I did when I was preparing for this panel was ask myself this question, and that is, will the COVID-19 pandemic change the fabric of the international tax order? So I'm looking for structural changes, and my aim is to see whether we're going to come out of this pandemic with a structurally different international tax system than we had before. So what has changed in the world as a result of this pandemic? Well, these are all themes that you've already heard a number of times during this Congress, and I'm sure they're familiar to all of you. So we've had some sudden swings in profitability of companies, business models have changed, government spending in most countries has skyrocketed, and we're all working at home. We're all sitting behind our computers at home joining in this conference rather than being in the conference room, which is sort of rather a shame, but okay, that's life. So I'm going to look at each of these things and think about what they do to the international tax system as we know it. Profitability. So we've had huge ups and downs. Some profits have gone down, some profits have gone way up. The profits that have gone down, the companies that are struggling, or the businesses that are struggling, have received huge amounts of government support, and we've heard earlier in the Congress about all the different ways that that happens. There will also be an awful lot of losses being suffered. So we have questions about how to deal with those losses. Will they get effective tax relief? How to deal with all their support packages? None of those really are new structural issues. Then we've got the companies that have made a large amount of money. So, and then that gives us questions about excess profits. And we've had various calls for excess profits taxation. And I'll come back to that in a minute because all these themes are interrelated. What else have we seen? Well, things have changed in the economy. So business models have changed. There have been some immediate changes, and that throws up a huge number of transfer pricing issues, but the next speaker, Guglielmo, is going to deal with those. Are we going to see structural changes to the world economy? Maybe. There have been calls to bring the production of vital products closer to home, for example. There have been many calls to never waste a good crisis and use the pandemic to come out of it with a much greener, more environmentally friendly economy. Those things, of course, change the underlying economy, but I don't think they change the taxation system as such, or not the structure of it. We've seen structural disparities among countries, so countries that were struggling with their budget and their economy and their social system before may be struggling more now that they have extra health issues to deal with. Again, that doesn't necessarily translate into a change in the international tax structure, although there's one issue there that I will come back to in a minute. Then we've had government spending. So governments all over the world have been spending huge amounts of money to support businesses, keeping people in employment. And then the question, who's going to pay? Because someone's going to have to pay for this in the end. Are we going to have a general tax increase? Well, eventually all of us are going to have to bear the burden. So yes, I think we're going to see, it seems inevitable, we're going to see a tax increase. But how is that increase going to be targeted? So are we going to make the millionaires pay, for example, or the rich or the very rich? And you've probably seen that over the summer, I think it was in July, an international group of millionaires published an open letter to their governments asking to be taxed more heavily permanently. But again, this is a discussion that was going on before. So we've always had discussions about the tax mix. We've always had discussions about, is it desirable, is it effective to tax the very rich more heavily? So that might be made more acute by the pandemic, but it's not caused by the pandemic. Then we've had the calls for excess profits taxes. And in the previous panel, Alison Christians was explaining her proposal, the global excess profits tax. These, again, I mean, this is not really a new pandemic issue. some of the arguments are based on the idea, well, the pandemic has caused a market failure and we need to correct that. I have to say, I find it difficult to pinpoint the market failure in many cases. And I was thinking about this and I thought, well, you know, maybe the competition lawyers have something to say about this. And an old school friend of mine happens to be one of the leading competition lawyers in the City of London. So I phoned her up and talked to her about it and said, you know, for example, with Zoom, do you see a market failure here? No. All she could see was the first mover's advantage. And so I think we've got to be careful with this. Is this really a market failure? Or is this just a company that happens to have the right product at the right time in the right place and therefore is able to make a lot of money? So although I can see, you know, there are arguments and plenty of arguments for taxing economic rent, here, if we're going to change the structure of the international tax system, maybe, but I think here there's a good case for talking to the competition lawyers first to decide exactly what we're going to do, how we're going to do it, how that plays in with competition law, how we're going to target it. And actually the friend I talked to was horrified at the idea that we would use taxation to deal with this issue because, in her words, taxation is such a blunt instrument. Cutting across all of this, of course, is the problem of international, or the issue of international solidarity. Because all governments are going to need money, but of course some countries are more able to fund that increase or fund that extra spending by raising revenue than others. And what the pandemic has shown us again, or it's just reinforced the disparities among countries in their ability to deal with issues like this. So we have a big question of international solidarity. I mean, the letter from this open letter from the millionaires, it's all very well, but it didn't address this issue. The money that they were talking about, what they seem to be talking about is paying to their own countries. I mean, they didn't have space in the letter probably to deal with this issue. But if we do go for international solidarity, so if we do, for example, have a global excess profits tax, and we find a way of increasing the revenue among countries, so not just having countries raise the revenue on the basis of what they deserve, if this crisis prompts us to move to a system where countries receive revenue on the basis of what they need, that would be a huge change. But is it likely to happen? I don't know. That's maybe a rather utopian idea. Then we have stay at home. So we're all at home now. Everyone's working at home. And that brings us a number of issues. And these have been addressed in the OECD paper that was released in April, I think. As you can see from my watch down here, I'm running out of time, so I'll have to speed up a little bit. So all sorts of issues that are raised by the problem of remote working, residence tests that are based on the presence of individuals, thresholds for taxing at source that are based on the presence of individuals. What the pandemic has done is made these issues more acute. I don't think it's caused these issues, it's made them more acute. This is a direction that we were going anyway. What this also does, of course, is raise questions about substance, because if you have remote employees, it might be much more difficult to work out exactly where the substance of a business, of a company is. And especially if that means then that the remote possibilities means that the activity of employees gets diffused across countries and it gets diffused across entities, because it's much more easy now. It's much easier now for employees from one part of the business to participate in processes in another part of the business. And one of the drivers of profit allocation cross-border is the location of individuals making decisions. And if they're spread all over the place, that becomes very, very much more difficult to resolve. But again, this is something that was happening anyway. You know, the digitalization, the remote working is maybe being given a huge push by the pandemic, but I don't think this is a new issue that has been caused by the pandemic. So if I were to conclude, I would say, yes, the pandemic is causing changes to the economy, but it's not changing it's not causing direct changes to the international tax system. What it's doing, it's accelerating existing trends. So digitalization, there's a lot more digitalization and a lot more digital business going on. Remote working, I think that was going to happen anyway, and that's really been given a big push, and now we're seeing the issues that come up as a result of that. The pandemic has made some existing debates more acute. So debates about the tax mix, should we be levying wealth taxes on the very wealthy, for example? It's brought very much into focus the issue of international solidarity and how to get revenue to the states that really, really need it. But again, those were things that were already happening. So I think my conclusion is the pandemic hasn't changed the system as such. It's brought into focus a number of things that were already happening. But I have one last question, and this really is a genuine question for me, and if there's someone in the audience who can answer it, I would love to hear your response. And that's this. We have a huge network of tax treaties in the world, and they so far have almost always been negotiated face-to-face. Are we going to see remote negotiations, and is that going to work? And I ask that because the one thing I hear from tax treaty negotiators is how important it is to get to know the other side, how important it is to talk to people face-to-face. And in fact, this is something, sorry, I need to stop my phone. And okay, this is something that I also heard on the news recently in connection with the Brexit negotiations, that the travel restrictions have meant that those are very much more difficult to carry on face-to-face as well, and how difficult it is to carry out negotiations when you can't talk to your counterparty and see them, look at them in the eye. So question two, if we have current or past negotiators in the audience, is this going to have an effect on our network, treaty network? Is that going to mean we're going to have fewer treaties maybe? Does it mean that the difficulty of negotiation is going to mean we're going to have more standardized treaties? Or maybe what it means is that you can get the message across to your governments and that treaty negotiators are going to be some of the few people who are allowed to travel around the world. Anyway, that I think is a real question for the future. And if, as I say, if there's a treaty negotiation in the audience, I'd love to hear your response to that. And that's my input for the moment on what I think the COVID pandemic is or is not going to change in our international tax order. Thank you.
Agora vamos passar a palavra ao professor Guglielmo Maisto para proferir a sua primeira fala no bloco do painel.
Good morning to everyone, and thank you for inviting me to this Congress. And what I shall do, I shall go through one very specific point regarding the pandemic emergency, namely the transfer pricing ramifications of the COVID-19. I anticipate that I shall be making comments on the other presentations during the debate, but for the time being I shall focus on the transfer pricing impact. If we turn to the next slide, we have a list of reasons for which this topic deserves attention. And the reason are in a list the impact of the crisis on limited risk entities, which prior to COVID-19 had no major risk function, comparability analysis during the crisis, and economic analysis. I'm referring primarily to the benchmark studies which all multinational companies do prepare when they establish their transfer price. The documentation is also an issue which does emerge in this period, and APA, Advanced Pricing Agreements, insofar as existing APAs might need to be renegotiated. If we go through all of those points, and we can move to the next slide, on the reason for reviewing the transfer pricing policy. Why should a multinational company do that? Well, I believe there are at least three main categories and reasons for that. First of all, the changes in the operations. If you look at the real world of manufacturing and distribution companies, we had supply chain disruptions, for instance, difficulty to have access to warehouses for distribution, warehouse in China, a group being placed in another jurisdiction and having difficulties to have access to the warehouse for distribution. That is certainly a big change which we have experienced during the period. A shift in production capacity. It was not uncommon that during the most difficult part of COVID-19, several companies have changed their manufacturing operations in the textile business, for instance, and they started to manufacture masks for the emergency or sanitary devices just to basically cope with the emergency and also reduce in a way fixed costs. That also is something which could not be expected. Or extraordinary costs which have been incurred, such as the cost to prevent the virus to basically expand and comply with the domestic regulations also in factories, offices, and so on. These are extraordinary costs which have been incurred. Also, in terms of people, we had changes, especially in functionality. Many people and managers in low-risk companies had to take extraordinary and very important decisions. For instance, the negotiation of a lease agreement with a landlord, which is a decision which could carry significant economic effects, and that was something which, in combination with the legal aspect, came into play precisely during the pandemic event. Many of us are aware of the operation of certain contractual provision, such as termination or renegotiation of contracts, which was required. If we move to the next slide, we have another element which comes into play in the review of the transfer pricing policies, and that is the question on whether or not limited risk entities should be affected. When an entity is guaranteed a remuneration, take a distributor who is guaranteed a cost plus margin. Does the pandemic event justify a change of the profitability of a limited risk distributor? Many tax authorities might say if there is a risk of a pandemic event, that risk should be borne by the entrepreneur and not by the limited risk. But the problem which does arise is the one relating to the dichotomy between limited risk and no risk. And the OECD guidelines themselves make a reference to the fact that also limited risk, a low risk function, situation which exists, for instance, in a limited risk distributor, does not mean that a loss-making transaction can never be made. It can never be taken into account. That is a quite important point which shall have to be addressed by tax authorities. If we look at the next slide, comparability analysis during the crisis, there is a need to look at comparability, to compare the contractual terms of a transaction, if the contract concluded by the related parties included a force majeure provision, the effect of governing law, functions performed, assets used, and risk assumed. That is also something which will need to be taken into account. And if we turn to the next slide, we have the economic analysis. Namely, the point is that many companies belonging to multinational groups are aware that when the benchmark analysis of comparables shall be available for 2020, namely the profitability of independent companies operating in the same business, the results of the 2020 should be lower compared to the results of prior years. So they know already that the profitability that they guaranteed within the group in prior years shall not be in existence for 2020, but the data are not yet available. So there is a need basically to cope with the situation in which I am aware that the profitability is lower because the benchmark analysis of the comparables in later years shall document that the 2020 shall present a downturn also for third parties. And indeed, that is one of the reasons for which many taxpayers are reviewing their transfer pricing policy in advance. If we go to the next slide, we have the need to justify a change in the TP policy for 2020 because of the pandemic event. And you can see on the slide at the very end, some tax authorities have already taken a position. The IRS in the US, in terms of transfer pricing and best practice on TP documentation, they acknowledge that a proper documentation which may document the negative and adverse results in 2020 might justify a distributor to fall outside the interquartile range of comparable companies' profitability. So there is already an acknowledgement in the position of a certain tax authorities that a well-documented change in reduction of profitability may be justified if the reasons for the downturn are well documented. The last point I wish to address, and we can turn to the last slide, we are aware of the large number of APAs which have been concluded in many countries, bilateral APAs, multilateral APAs, agreements which have been reached between multinationals and tax authorities. And many of these agreements, on the basis also of the OECD guidelines, provide for a possibility of revising or terminating the agreements when there is a significant change in the business operations, or when economic circumstances which were unforeseeable at the time of the conclusion of APA suddenly occur. And that is one of the issues that many tax authorities are facing. Some tax authorities are taking the lead and asking taxpayers who have concluded APAs to declare and to inform the relevant tax authorities on whether such conditions, such revisions or termination are there in order to basically start renegotiating the agreements. Some other countries are waiting for a position by the OECD. The OECD, as Joanna Wheeler indicated, has already partially, in a very soft way, taken a position on certain issues regarding the application of the tax treaties in the pandemic environment. And we understand the OECD is working also on the transfer pricing ramifications of COVID-19, and many tax authorities are waiting for the results of the work of the OECD by year end. That is basically my presentation on the transfer pricing of COVID-19, and I should be pleased to carry on with some comments during part 2 of our panel. Thank you.
Thank you, professor. Antes de iniciarmos o segundo bloco do nosso painel, vamos ao quiz. Marta.
Bom dia, boa tarde a todos. Na verdade, vamos aguardar nossa equipe técnica colocar o quiz aí na tela para todos responderem.
Pronto. Agora, duas perguntas interessantes. A pandemia da Covid-19 vai alterar a estrutura da ordem tributária internacional, sim ou não? E a crise econômica decorrente da pandemia da Covid-19 vai aumentar a busca por mecanismos para economizar tributos? Esses são os dois quiz, vocês já podem responder e vamos dar sequência ao nosso painel, cujo segundo bloco ele vai tratar das consequências da pandemia sobre a economia digital e seus efeitos sobre o direito tributário. E para proferir a sua primeira fala, eu convido o professor Vikram Shande.
Thank you, Andrea, for that introduction. And thank you, Professor Maisto and Professor Wheeler, for your insightful comments on transfer pricing and tax treaties. Keeping aside the transfer pricing and tax treaty debate, what I'm going to speak to you about today is about the consequences of COVID-19 on the OECD Digital Project. Now, just to give you a little background for Pillar 1 and Pillar 2, is that before I get into the discussion, we've seen that COVID-19 has actually shown that many businesses can flourish in the times of a pandemic. So we've had many automated digital service kind of businesses like the big Facebook, Netflix, Apple, so on and so forth, big digital companies who've made a lot of profits. At the same time, you've had a lot of consumer-facing businesses, such as pharmaceutical companies, fast-moving consumer good companies, which are selling food and ice cream. They've also somehow improved their bottom line position as a result of the COVID-19 crisis. So some businesses, which are actually digital as well as consumer-facing businesses, they have flourished in the Corona times. At the same time, what the COVID-19 crisis has shown us that because of all the packages that were given out by the governments of almost all countries are handing out packages to counter the coronavirus. The government needs money to fund these packages, these measures. So the government needs to raise revenues. That's the bottom line. So the COVID-19 crisis has shown that governments need to raise revenues. Now, these revenues can be raised on a unilateral basis, on a bilateral basis, or a multilateral basis. Now, what is the approach that is currently being considered? So at the OECD level, Pillar 1 and Pillar 2 of the digital economy debate wants a multilateral solution in place, both for Pillar 1 implementation and both for Pillar 2 implementation. They want some kind of multilateral consensus around these two pillars. Whereas on the other hand, the UN favors bilateralism, and this you can see in the new article that was proposed by the UN with respect to fees for digital services or fees for automated digital services. That solution, in my opinion, is a very basic solution. It's like a kindergarten solution, so I wouldn't really spend too much time on that. But at the same time, we've seen that some other countries want to follow the unilateral path. So you've had many common law countries, UK and Australia, introducing diverted profit taxes. And at the same time, many European countries are preferring for the DSTs, India equalization levy, so on and so forth. The EU currently, it favors a multilateral solution, but at the same time, it's saying if there's no multilateralism in place, we will introduce digital service taxes. And the recent proposal from the French Finance Ministry also supports the creation of a digital service tax. So you have these different policy-making organizations, the OECD, UN, and EU, and they have different perspective and, of course, different countries with respect to digitalization. But the bottom line is all these measures want to raise revenues. Now, let's move into the Pillar 1 debate, because I see there's a lot of confusion around Pillar 1. So I just want to explain how Pillar 1 works with a very simple example. And because Pillar 1 allocates more taxing rights to market countries, I will use Brazil as an example as a market country, because this conference is organized by Brazil, the Brazilian organizers, so I'll use Brazil as a market country. Now just take a very common business model. Common business model would be, let's say, a US parent, which would set up a principal or a centralized business model, either operating from Switzerland, like a principal company. The principal can be in Switzerland, Luxembourg, Netherlands, Ireland, Singapore, Hong Kong. It can be in all these small and mid-sized entities, or the US parent could be selling directly into the Brazilian market. So let's just assume that in this example, the US parent sets up a principal company in Switzerland, and it licenses all its trade intangibles, marketing related intangibles to the Swiss company to sell outside the US. And in return, the principal company pays a royalty to the US parent. Common business model. Now let's assume in the first situation, there is remote sales that are being made in Brazil. So without this multinational group having any physical presence as such in Brazil. So remote sales are being made here. In the second situation, let's just assume that the multinational, the principal company, is selling its products, or mostly its products, or maybe its services, to a low-risk distributor entity in Brazil, and the Brazilian entity is then selling those goods to the clients. In the third situation, let's just assume that the principal has set up a full-fledged distribution entity in Brazil. So it has extreme amount of operations which have been set up in Brazil, and it's making sales through these full-fledged entrepreneurial operations. Now, with respect to Pillar 1, now what does Pillar 1 aim? Now, if you take these three different situations, in the first situation, because remote sales are being made into Brazil, Brazil would be entitled to an Amount A allocation. That is the Amount A which will be determined on the basis of a M&E group approach, because if you look at the current framework, tax treaty rules, transfer pricing rules, they are rooted to the separate entity philosophy. But Amount A of the OECD's digital project reallocates profits to market countries based on M&E group profits, multinational group profits. So Amount A would actually be allocated to Brazil in this example, in the first situation. Now, in the second situation, when the multinational is selling into Brazil through a limited risk distributor, Brazil would be allocated something known as Amount B. Now, what is Amount B? Amount B is just like a fixed margin, which is going to be based on the ALP. You see many multinationals, they operate with limited risk distributors. These limited risk distributors are usually compensated on the basis of 3% on sales, 2% on sales, 5% on sales, based on the industry in which they operate. So this is going to be a fixed margin based on the ALP that will be allocated to Brazil. And somehow, you know, Brazil already has special rules on transfer pricing. So amount B stays within the existing transfer pricing framework. And probably, I think it's also in line with Brazil's entry into the OECD, in the sense that the Brazilian transfer pricing rules are currently being rediscussed, and probably this kind of fixed remuneration based on the ALP is also in line with the Brazilian transfer pricing rules. But at the same time, in addition to an amount B allocation, which could be 3 or 4% on sales, Brazil will also be getting an amount A allocation, which is built on the residual profits of the multinational enterprise. Now, if in the third situation, when the multinational is operating in Brazil through full-fledged operations, that is where probably there's going to be an overlap between the profits actually being reported by the full-fledged distributor in Brazil, which is known as amount C of the OECD digital plan on pillar 1, and amount A. So because in both situations, residual profits are being booked in Brazil in the third situation. So in this kind of situation, there could be a situation of double counting. But I would like to say at this stage that if the full-fledged distributor is operating in a loss situation, then definitely there's going to be an amount A allocation to Brazil. Now, if Brazil as the market country in the 3 situations is going to exercise its taxing rights, some entities within the multinational have to provide relief from double taxation, either through the exemption method or through the credit method. And this is going to be the principle, because that's the first point of contact with respect to the sales. Now, if the profits of the principal are low, or it's a loss-making principal, then probably because the principal pays a royalty to the parent is going to provide relief from double taxation. Now, what does this show? Now, this shows that actually some revenue is going to be allocated to developing countries like Brazil, or market countries like Brazil, and probably the amount which are going to be allocated to these market countries is going to be much higher than any allocation that will be made under a unilateral measure, which only targets a narrow set of businesses. Because all the unilateral measures that are being contemplated right now, they are applicable only to a selected number of automated digital businesses. But amount A, pillar 1 of the OECD project, is broad. It applies to automated businesses, consumer-facing businesses. So probably market countries are benefiting from the pillar 1 proposal, contrary to what has been said in other panels or other discussions that it's not really good for market countries. Well, it all depends on the reallocation percentages that are going to be discussed in the amount A allocation. Now, with respect to pillar 2, I've been hearing that pillar 2 is bad also for developing countries. But here, once again, I just want to show you how these rules actually are going to work. Very simple example. We have a German parent which has an intermediary entity in between, and that this entity is a genuine operating entity. It's carrying out value creation activities, full-fledged activities, but it is a zero tax subsidiary. So let's assume it's an IP box in the intermediary location, and this IP box is licensing its IP to a Brazilian entity, and the Brazilian entity is paying royalties of $100 on this income. So how do the pillar 2 rules work? Now, the pillar 2 rules actually have different mechanisms. There is one set of rules which are known as the income inclusion rule, and the second, which is also linked to the income inclusion rule, is the undertax payment rule. The top-up rate for that rule is going to be agreed at 12.5%. For example, that's the current rate that is being floated around. Whereas on the other hand, there's another rule which is known as a subject to tax rule. And actually, this rule is in favor of developing countries or source countries. Let me not use the word source or market. Let's just say source countries where the payment is actually being made from. So how would this rule work? So on this 100 of payment that has been made from Brazil to the intermediary location, contrary to what everyone is saying, that this proposal favors residence-based taxation, the subject to tax rule would apply first as per the leaked document, which has been the pillar 2 document, which has been leaked. So on this payment of 100, Brazil would have a first right to tax this income. Well, the minimum tax rate under the subject tax rule and the minimum tax rate under the income inclusion rule, they're different. So here, Brazil would apply, if it signs up to pillar 2, they would tax $7.5 US. On the other hand, if Brazil as a market country exercises taxing rights under the subject to tax rule, which is a rule linked to tax treaties, Germany would apply the income inclusion rule. But on the income inclusion rule would apply this income of 100, which is not taxed in the intermediary location. Germany would tax it at 12.5%, the top up to the top up rate, but it will provide a relief for the taxes that have been paid under the subject to tax rule. So effectively, the tax that will be paid in Germany is going to be $5. Now, what happens if Germany, for instance, does not want to apply its income inclusion rule? Or it could be a German parent, or for example, it could be an Indian parent, Chinese parent. And what happens if the state of residence does not want to apply its income inclusion rule? Then the country of source, once again, under the undertax payment rule, would apply and would tax the $5, which would be allocated, which would have been allocated to the parent, but now it will be reallocated back to the source. So in effect, if the income inclusion rule would not apply at the German level, then Brazil would be taxing around $12.5 of this income. So in one way, if you look at the priority of these rules, the way they are applying, if the subject to tax rule is given into effect, comes into effect, it's a rule which is actually beneficial for source countries, the way the pillar is being designed right now. And this could actually allocate more revenue to market countries and developing economies, not only like Brazil, but also to India, China, so on and so forth. So contrary to what has been said about the OECD being really bad, or the pillar of digital projects are against developing countries, market countries, with these two examples, we can see that there is going to be more revenues that market countries or developing countries could actually raise. Just to sum up, I know I've already exceeded my time. I'm sorry for that. Just to sum up, I would just like to say one thing on pillar 1. Now, if market countries just go over the board and they start arguing for higher income reallocation percentages to the market country, then what OECD members are going to say is that, okay, if you reallocate back excess amount of corporate income taxes to market countries, then OECD member countries, I'm sure that's going to be in the future, what they're going to do is they're going to argue for origin-based consumption taxes. Because under the current framework, when a company in Brazil sells something in India, India collects VAT, Brazil collects corporate income tax. But you want to shift the balance and you want to say, okay, India should pay more, India should get more corporate income tax, then Brazil should argue logically for more VAT allocation. So you would see developed countries arguing for more origin-based taxes, consumption taxes. Now, clearly to implement these proposals, Pillar 1 and Pillar 2, a multilateral framework will have to be developed. And this framework is absolutely necessary to avoid compatibility issues with tax treaties as well as EU tax law. So multilateralism is the key. Now, contrary to what has been said before, as well as on other forums, unilateralism is the worst way countries can actually go forward. Unilateralism is just going to create problems, time and forth. It's well documented literature. I don't need to repeat all the arguments. Unilateralism is not what we should focus on. The focus should be on a multilateral solution at the OECD level. And if you think about it, the OECD is not really silly. Huh? They don't think that they're a silly organization. They don't know about the market country perspective. Then that they don't know about the developing economies perspective. And the way the proposals have been designed, it looks into the entire system as a whole. It also looks into income tax, corporate income tax, consumption taxes. So
conclusions. Your conclusions. Time.
Yes, sorry. And just to finish it off, the proposal should be the proposal, the way they stand, at least in my opinion, they look balanced for both OECD and non-OECD countries, given the fact that here we are trying to tax corporate income tax, not consumption taxes. thank you for that. And I'm sorry that I exceeded my time, but I'm very passionate about this topic.
You are welcome. Agora vamos convidar o professor Alexandre Alkmin para proferir a sua palestra. 12 minutos, Alexandre.
Bom dia a todos, boa tarde aos colegas que estão na Europa. Eu procurarei economizar um pouco do meu tempo, mas não sem antes parabenizar o IBDT e a Faculdade de Direito da USP por esse magnífico evento, das pessoas, respectivamente, do professor Ricardo Maria de Oliveira, professor Luiz Eduardo Chueire, agradecer ao professor Luiz Flávio Neto pelo convite, professora Marta e professor André pela organização deste painel. E coube a mim falar sobre um problema que já vinha existindo, já vinha sendo estudado, como a professora Willer ressaltou. A Covid não criou este problema, mas catalisou problemas que já existiam e que se tornaram mais presentes e com a demanda de soluções mais urgentes do que vinha ocorrendo ou exigindo uma certa movimentação e compreensão desses novos problemas que a economia digital traz e que foram otimizados, que foram empurrados para o cotidiano de todos a partir do Covid-19. E o meu ponto especificamente irá se relacionar à questão da utilização de paraísos fiscais. A título de contextualização, o enfrentamento dos paraísos fiscais remonta ao relatório Harmful Tax Competition e desde lá a sociedade internacional, os estados e as organizações internacionais vêm se ocupando de compreender e tentar restringir os efeitos dos paraísos fiscais na perda arrecadatória por parte dos estados de economia normal. Além disso, existem outros efeitos acerca da utilização indevida de paraísos fiscais que também são objeto de enfrentamento pela comunidade internacional. É possível observar que os paraísos fiscais, em regra, são utilizados com 3 funções bastante importantes. Primeira delas, centro financeiro. Os paraísos fiscais, eles proporcionam um mecanismo de pagamentos e proporcionam mecanismos de mobilidade financeira muito mais rápido, muito menos burocrático e aumentando a eficiência das transações financeiras entre empresas de um mesmo grupo econômico multilocalizado. Se nós imaginarmos que um país de tributação normal, como o Brasil, uma transação financeira pode demorar 3 a 5 dias, não sem antes provocar ou demandar uma série de burocracias, como preenchimento de cadastros, justificação das operações financeiras, num paraíso fiscal, facilmente se realiza uma transação financeira no prazo de 1 dia para cumprimento no dia seguinte. Paralelamente, os paraísos fiscais também sempre foram muito utilizados para fins de planejamento tributário, diminuindo o rendimento tributável no nível global dentro de um grupo de empresas, principalmente pelo estabelecimento de empresas de tecnologia ou que detêm IP, pela prestação de serviços por empresas localizadas em paraísos fiscal, por meio de empresas financeiras para empréstimos entre empresas do mesmo grupo econômico, pela intermediação de compras e vendas por meio das trading companies e até mesmo por meio das holding companies na realização do planejamento tributário de CFC. E, por fim, os paraísos fiscais sempre foram também amplamente utilizados para fins de lavagem de dinheiro, ocultação patrimonial. A opacidade conferida historicamente pelos paraísos fiscais aos detentores dos patrimônios ali alocados sempre foi um desafio a ser enfrentado pelos países de tributação normal. No entanto, os paraísos fiscais têm mudado no curso dos últimos tempos, principalmente após os eventos de 11 de setembro de 2001 e a crise financeira de 2008, foram desenvolvidos mecanismos de restrição da utilização dos paraísos fiscais, especialmente relacionados àquela opacidade, àquela falta de transparência que sempre caracterizou os paraísos fiscais. Foram quase obrigados a acabar com as chamadas contas numeradas, foram extintas as sociedades holding com ações ao portador e, mais recentemente, uma série de instrumentos vieram pressionar ainda mais a funcionalidade tradicional dos paraísos fiscais, principalmente quando utilizados para fins de planejamento tributário e quando utilizados para fins ilícitos, para os fins de lavagem de dinheiro. Nós identificamos claramente uma postura agressiva do plano BEPS, coordenado no âmbito do G20 da OCDE, com o objetivo de restrição dos efeitos das operações por empresas localizadas em paraísos fiscais. E isso vem com o estabelecimento e a fixação do conceito de DEMP, né, desenvolvimento, aprimoramento, manutenção, proteção e exploração da atividade e de propriedade intelectual com fins à atribuição de quem é o verdadeiro titular daquele direito, quem é o verdadeiro titular, buscando a substância daquela entidade, buscando a substância daquela empresa. Um outro conceito que tem ganhado cada vez mais importância, principalmente nas revisões dos tratados em matéria tributária, pós-revisão do modelo de tratado de 2017 pela OCDE, é o próprio conceito de beneficial ownership, quem é o beneficiário efetivo dos valores pagos, uma vez que se ocorre uma intermediação por meio de um paraíso fiscal e se identifica que não é ele o beneficiário efetivo, é possível simplesmente se desconsiderar essa intermediação do negócio feito por intermédio de um paraíso fiscal. Mas, principalmente, por meio da Convenção Multilateral de Intercâmbio de Matéria Tributária, celebrado por mais de 147 países e já em vigor, totalmente em vigor, desde 2018. Imaginem que, para o Brasil, nós realizamos intercâmbio de informações financeiras por meio do relatório CES com 100 dos 147 signatários da Convenção Multilateral e realizamos intercâmbio de informações por meio do relatório CBC, o Country by Country Report, com todos os membros dessa Convenção Multilateral. O Brasil, nesse ponto, possui uma particularidade muito interessante, é que a Receita Federal do Brasil está altamente equipada para processamento desses dados e buscar realmente incrementar a sua tributação a partir dessa tributação. Muito bem, é nesse contexto que surge o coronavírus. É nesse contexto que surge a Covid-19, trazendo uma nova realidade na vida das pessoas e na vida das empresas. As pessoas passaram a trabalhar em home office, as pessoas passaram a realizar compras por meio digital, seja diretamente em lojas físicas, seja por meio de marketplace, mas principalmente chama-nos a atenção os serviços digitais e os games, os jogos digitais. A gente pode, eventualmente, achar que jogos não é uma questão relativa ou relevante para fim de tributação, mas imaginem vocês que no ano de 2019, esse setor apenas de jogos digitais movimentou 152 bilhões de dólares no mundo. Quem tributa, como e quando? Principalmente quando nós pensamos em que é possível que essas operações digitais sejam todas processadas por meio do blockchain. Dentro do blockchain existem inúmeros ativos criptografados, ativos eletrônicos, que nós chamamos crypto assets ou crypto coins, as moedas eletrônicas. É bastante comum e é cada vez mais comum, principalmente no pós-Covid-19, nós identificarmos operações de aquisição de bens e aquisição de direitos e aquisição de serviços por meio de pagamentos realizados no âmbito desse blockchain. Existe, dentro da funcionalidade do blockchain, algo muito interessante. Os estados, eles conseguem identificar a existência de um eventual criptoativo no momento em que a pessoa no mundo real adquire a sua moeda eletrônica ou o seu criptoativo por meio das chamadas exchanges. Mas as operações que se realizam entre exchanges, aliás, as operações que se realizam entre moedas eletrônicas dentro do sistema do blockchain, eles não são acessíveis pelos estados, inclusive porque essas informações, apesar de virtualmente abertas, não dão segurança com relação a quem são os verdadeiros titulares desses ativos. E não é por isso, aliás, e é exatamente por isso que as grandes empresas de tecnologia têm buscado criar suas próprias criptomoedas, de forma que se possa realizar operações de aquisições de direitos e aquisições de benefícios e de serviços dentro daquele universo da criptomoeda, dentro daquele universo eletrônico, sem que esses benefícios e essas atividades operacionais sejam alcançadas pelas atividades fiscais. Daí que a gente identifica o que tem sido chamado ultimamente como os Digital Tax Havens, ou os paraísos fiscais digitais, uma vez que eles podem ser utilizados exatamente com as mesmas funcionalidades que outrora eram utilizados pelos paraísos fiscais normais. Eles podem ser utilizados como centros financeiros e imaginem vocês que se uma operação financeira por meio de um paraíso fiscal geralmente demora um dia, uma operação por meio do blockchain em aquisição e remessa de recursos para um outro país pode ser feito em nada mais, nada menos do que 3 minutos. Eu já vi uma operação em que uma pessoa transformou reais em ienes na China em exatamente 3 minutos. Ainda, para fins de planejamento tributário, existe uma destruição dos conceitos de residência e dos conceitos de fonte quando se trata de operações dentro do blockchain. Não se sabe exatamente quem é o residente, não se tem exatamente a definição qual é a fonte desse rendimento, principalmente nas operações de compra e venda da própria moeda eletrônica dentro do sistema de blockchain. E, por fim, a opacidade absoluta do blockchain provoca a possibilidade de lavagem de dinheiro numa extensão só comparável quando existiam as contas numeradas e quando existiam sociedades anônimas com ações ao portador. O que fazer nesse contexto é a grande pergunta que temos atualmente. Temos um incremento da utilização desses sistemas. Imaginem que um Bitcoin em janeiro de 2017 custava $829, hoje um Bitcoin custa $10.986,50, mostrando a importância do crescimento deste mecanismo como um sistema de pronto pagamento ou até mesmo de investimento, e não temos respostas para essas perguntas. Os estudos mais avançados hoje se encontram por meio do Comitê de Assuntos Digitais de Tributação Digital no âmbito da OCDE, e também existe um comitê dentro do Parlamento Europeu que tem buscado soluções ainda sem respostas definitivas. Agradeço a oportunidade dessa participação e fico à disposição para as nossas discussões.
Excelente, Alexandre, parabéns. Bom, eu acho que a organização vai mostrar o resultado aí da enquete, se quiserem mostrar. Olha aí, pessoal, 49% sim, 51% não para a primeira pergunta, e 93% sim para a segunda e 7% não. Ok, muito obrigado. Bem, dando sequência ao nosso painel, nós vamos agora para os debates e eu gostaria de imediatamente convidar a doutora Marta Leão, moderadora do bloco, para fazer as suas colocações. Marta.
Obrigada, professor André. Bom dia, boa tarde a todos, né? Dependendo do fuso onde estiverem. Olha, muito interessante o resultado da primeira enquete, porque a gente vê um empate técnico, né? Ou seja, realmente uma dúvida entre as pessoas se a pandemia vai, de fato, trazer mudanças definitivas para a ordem tributária internacional ou não. Nesse contexto, teve uma pergunta do Michel, mestrando do IBFD, aqui no chat, que eu gostaria de direcionar a todos os nossos painelistas, uma pergunta muito interessante, né? Se a pandemia vai ser realmente crucial para as mudanças que a gente vai ter, enfim, para possíveis mudanças na ordem tributária internacional, ou se ela vai ser simplesmente um argumento político, né, a ser usado pelos estados, né, para dar velocidade às propostas já em andamento, né, a mudanças que já vinham acontecendo e que talvez não fossem implementadas de forma tão rápida. Eu acho que isso fecha perfeitamente com a apresentação da professora Joanna, né, e que, inclusive, escreveu um artigo, gente, no livro, nos Anais do Congresso, vale muito a pena ser lido. Ela traz todas essas questões nesse artigo. E se a gente vai ter, de fato, esse incremento, né, da solidariedade entre os países, ou se, ao contrário, a gente vai ter uma luta ainda mais feroz, né, atrás de receitas, em função dessa necessidade de aumento de gasto público que foi vivenciado por todos os países que sofreram, né, não só uma crise econômica, né, enfim, mas uma crise sanitária que demandou esse aumento de gasto público. Eu queria, para a gente começar os debates, passar primeiro a palavra para o professor Maisto, já que ele gostaria de comentar a apresentação da professora Willer, para logo em seguida passar a palavra para ela, para que ela possa responder, né, as possíveis críticas ou, enfim, sugestões que o professor Maisto vai trazer. Professor Maisto, a palavra é sua. 5 minutos.
Thank you. Thank you, Martha. And can you hear me? Can you hear me well? Okay. My comments on the future of taxation in the pandemic, after the pandemic emergency. I have 3 comments, basically. First of all, yes, I believe that we may have some, let's say, changes relating to the way business is conducted, primarily remote work, but I don't think that is going to be a major change, especially cross-border. It's going to be some increase of remote work, but if we look at the ramifications of it on a cross-border basis, I don't think that is going to be a dramatic change compared to the situation where we are now. Second aspect on solidarity. I think that Joanna Wheeler mentioned solidarity, but I don't think solidarity may, let's say, out of a sudden come up because or after the pandemic event. We know in Europe, in the European Union, when we have emergency regarding immigrants from third countries, and few member states are struggling with that with no help. Or if we look at the problem of which we just experienced regarding the recovery fund and lots of disagreement between countries on what we call solidarity. So I think it's more a wishful thinking, but in reality, each country shall continue to look at its own, let's say, pocket, so as to speak. One feature which perhaps countries may make use of after the pandemic event, if we go into technicalities, is, for instance, measures which have been taken for business during the pandemic emergency might remain. I'm making a reference, for instance, to losses carried back for companies. Some countries, such as the US, have reintroduced the possibility for companies to not so much to carry forward the losses, but to carry back the losses. a measure which they have always introduced during emergency situations. They did during the financial crisis. They have frozen the measures and they have reintroduced the losses carried back. Other countries have done the same. That is something that some countries might maintain in the future. Final point on excess profit. Some countries, certainly my country, have introduced in the past what you call excess profit tax on certain businesses, but we have faced constitutional problems because taxing differently different businesses, it is possible, but you need really to find a solid argument in order to avoid violation of the principle of equality or violation of the principle of ability to pay. So I think that excess profit tax is something which may face difficulties. So overall, my conclusion is that we are facing a challenge which Vikram and other speakers have addressed on Pillar 1 and Pillar 2. That certainly may really change international taxation, but on the ramifications on COVID-19, if COVID-19 may really change the rules, I don't think that may have very significant ramifications. And if you are asking me what is the area which one would need to look at more in the future, then I would say dispute resolution, because at present in many countries, and I would include also Brazil, Italy, and many others, a dispute resolution, certainty and clarity on international taxation is an issue, and the dispute resolution mechanism may be very helpful. And in Europe, we have just passed a directive for arbitration on tax treaties, and that may be the future in the years to come. Thank you.
Thank you, Professor. Obrigada, Professor. Joanna Wheeler, a palavra é sua.
Thank you. Well, actually, Guglielmo, I mean, I think you and I agree with each other. So to address some of the points you've raised, you said international solidarity is not likely to happen. Well, this is my point exactly. I don't think it is. What the pandemic has done has highlighted the differences between countries. My point there is that if what comes out of this is international solidarity in the sense of some mechanism that enables needy countries to obtain some of the international tax revenue as of right, then we've had a fundamental change in the international tax order, but I don't think that's going to happen. So I think we agree on that one. The excess profits issue, yes, I mean, I also agree with you that this needs very careful consideration. And in that respect, I think it would be useful to go and talk to the competition lawyers, because they're the people who've been thinking about market failure and what might be excess profits for a long time. So I think there might be a very fruitful conversation to be had there. Answering the questions about the pandemic, this was a question that came up in the chat a while ago. And the question was, is the pandemic the key to further changes, or is it a political argument to speed up pending proposals? I don't think it's going to be an argument to speed up pending proposals. It might be a key to push certain proposals like environmental taxes, because of all these calls to come out of the crisis in a better way. So there are plenty of calls to do that. People who want to, use the crisis to move to a greener economy, and taxation might be part of that package that states use to try and push us in that direction. Is it the key to further changes? I think what's happening is, as I say, it's not that the pandemic is causing changes, but of itself, but it's accelerating trends. And one of those trends, something I didn't have time to talk about earlier very much, is the remote working. And I think that's something that was going to happen anyway, but the pandemic has pushed it very much, pushed it forward very fast. And if you look at the response of the OECD, which is now saying in the paper about the interpretation of treaties, well, yes, they know that, just absolutely counting days is not entirely what we meant. You have to look at the intent, and they're bringing in the intent into the equation. And you look at what's going on with the pandemic, with remote working, and the issues that's going to raise, and whether, you might have source state taxation issues because of people being stuck in states and things like that. That whole debate, what that brings up to me actually is just the general questioning of the importance of physical presence. So for a long time, the location of individuals, their physical presence, has been an important part of the international tax system for residence purposes and for source state thresholds. And the reaction to the pandemic, where people are then being forced to be in places they didn't plan to be, or to work in places they didn't plan to work, and the debate that's brought up brings into question the reliance on physical presence. And I think what that does is accelerate the debate, which was already there. I mean, there have already been articles and debates about it. It accelerates the debate as to, wait a minute, how important should physical presence actually be? So the pandemic hasn't caused that issue, but it does throw the debate into relief, and it sort of accelerates the issues that we've got to deal with. That's the point I'm making. Thank you.
Thank you, Joanna. Professor Vikram, agora eu vou passar a palavra para você tecer seus comentários e responder a pergunta do chat, mas se você puder fazer em 3 minutos, porque nós estamos um pouco apertadinhos de tempo. Obrigada.
Surely, thank you for that, for giving the floor back to me. I know I exceeded my time, so I will not take too much time here. I'll keep my comments to a minimum. Well, I agree with what Professor Maisto, Professor Wheeler have already mentioned, as well as Mr. Alkmin, who's given a very nice presentation. Coming back to the comments of Professor Maisto and Professor Wheeler, now you see, what I see is that, international tax law is currently rooted on the separate entity principle. So like I mentioned to you before, tax treaties and transfer pricing rules apply at a separate entity level within a multinational group. They treat each and every entity on a separate basis. Within the separate entity principle, I think one of the big areas where a lot of improvement needs to be done is not really in the tax treaty area, but mostly in the transfer pricing area, to build more certainty around transfer pricing and the application of the arm's length principle. Because right now, the way the post-BEPS arm's length principle applies is that for me, it's just a negotiation tool between taxpayers and tax administrations to come to some kind of agreement. So the arm's length principle is quite complicated, and we need to do something around that to make it work effectively. And Professor Maisto touched upon that very nicely. He said dispute prevention and resolution, that's the key. That I think that's really the way forward within the separate entity principle, dispute prevention and resolution. But at the same time, I see that international tax law will evolve, especially with respect to taxing multinational groups. It will move away from the separate entity approach and move more towards a M&E group approach. The M&E group approach could be in the form of a Pillar 1 solution or a Pillar 2 solution at the OECD level, or the EU which is again back on the table within the EU with respect to reallocation of multinational profits, or probably some other kind of solution. But I do think that, we are going to live a very interesting time in the future. If we have, we'll be exposed to a separate entity approach and an M&E group approach, and both of them are going to apply parallelly on various matters. Probably 100 years down the line, because we spoke about 1920s, now we are in 2020s. 2020 is where we are seeing movement to the M&E group approach. Probably into 100 years down the line, we will completely get rid of the separate entity approach and move directly to the M&E group approach. So that could happen 100 years down the line. I don't know. This is just a guess for the future. The floor is back to you, Martha.
Thank you, Vikram. Eu quero agora passar a palavra para o professor Alexandre e até peço, enfim, acho que é muito interessante. É muito interessante para quem for de fora, né, e para os professores estrangeiros, trazer isso para o contexto brasileiro também. Será que essa pergunta do Michel não se aplica porque a gente tem vivido no Brasil, já que a pandemia tem sido trazida muito fortemente, não só em projetos de lei, mas também em decisões do próprio Supremo Tribunal Federal para justificar determinados efeitos?
No contexto internacional, eu concordo com os meus antecessores, só que com uma observação. Eu acredito que se não existia consenso em vários dos pontos que estavam em discussão, esse consenso se torna ainda mais difícil em um momento de crise financeira. E todos estamos passando por crise financeira muito forte, e além disso, e paralelamente a isso, nós já observamos um movimento de um certo unilateralismo, principalmente por parte dos Estados Unidos, com uma série de medidas e políticas, inclusive em matéria fiscal, que vêm sendo adotados a partir do último governo, que tornam, nesse sentido, um pouco mais difícil chegarmos num acordo para a evolução daqueles tópicos que já vinham sendo discutidos. Mas já pegando o gancho no que você colocou, Marta, aqui no Brasil, isso é muito interessante, nós temos identificado recentemente um número de julgamentos no Supremo Tribunal Federal em matéria tributária sem precedentes na nossa história da nossa Corte Constitucional. Questões que estavam pendentes de julgamento por 5, 10 anos estão sendo julgadas porque os julgamentos são virtuais, sem a presença dos advogados, sem a presença da imprensa, sem a presença dos fatores de pressão, e essas decisões são apenas colocadas virtualmente por parte dos ministros, sem que tenha um amplo debate com a comunidade jurídica acerca dos posicionamentos que estão sendo adotados. Da mesma forma, nós temos inúmeras discussões legislativas, até mesmo de reforma constitucional em matéria tributária, uma reforma constitucional tributária bastante ampla, que também tem sofrido uma restrição muito grande por parte da sociedade e que nós, na verdade, que acompanhamos de perto o trabalho legislativo, quase ficamos sem dormir, porque a qualquer momento, numa sessão legislativa, aparece o relatório de uma comissão de Constituição e Justiça, o projeto é colocado e julgado e votado por parte do Parlamento brasileiro, sem que haja um procedimento legislativo normal, comum, com os debates nas comissões e com ampla participação da sociedade, como, em regra, isso acontecia até então. Então, especificamente, internamente no Brasil, a gente tem visto, sim, uma oportunidade política para resolver ou para decidir questões tributárias a despeito e divorciado da participação da sociedade brasileira.
Obrigada, Alexandre, especialmente por se ater no tempo e ainda conseguir fazer comentários e responder a pergunta que eu te propus. O professor Maisto pediu a palavra. Professor, eu posso lhe dar a palavra por 2 minutos para um comentário final, para depois passar a palavra para o André. Professor Maisto.
Thank you so much for giving the time. I just wanted to go back to one point regarding how countries may interpret COVID-19 differently. Reference was made, for instance, to the guidance the OECD gave on physical presence in a country because of a lockdown, with some sort of mitigation, which was recommended by the OECD, saying that because of the special circumstances, then physical presence and resident by reason of a lockdown might be taken away. It may be interesting that Spain adopted a ruling, published a ruling in 17 June 2020, taking precisely the opposite direction. A couple of Lebanese individuals were stopped in Spain and they could not expatriate because of COVID-19. And the tax authorities took the position that the days spent in Spain had to be considered for the purpose of tax residence, regardless of the emergency, at least when the legislative restriction for moving outside Spain were lifted, which happened early June, there was no longer any reason for lifting the number of days Spain. So in a nutshell, you can see already that countries are taking different positions. I know Australia and the UK have taken a different view. So that's why I think arbitration is going to be very helpful in the future. Thank you.
Obrigada, professor. Eu queria, antes de passar a palavra para o André, agradecer a coordenação, parabenizar a coordenação pela organização desse evento. A gente teria muito para discutir, são pontos realmente muito polêmicos, né? A resposta do quiz não deixa de evidenciar isso. Então, eu queria sugerir a todos que lessem os anais do Congresso. Vários dos painelistas apresentaram textos exatamente sobre esses pontos e que podem ser objetos de futuras discussões. Com certeza, nossas discussões não terminam aqui, elas começam, né? E a gente vai, com certeza, ir além nesses tópicos no futuro. Muito obrigada pelo convite. Eu passo a palavra para o professor André Dantas.
Em considerações finais, já agradecendo a todos os membros da mesa, palestras brilhantes, debate interessante, e chamar atenção apenas para um detalhe. A gente está vivendo um momento dificílimo de pandemia, mas o contexto internacional da tributação nunca foi um contexto fácil. A queda de arrecadação tributária que determinou a abertura do projeto DEPS, coordenado pela OCDE, nada mais, nada menos de decisões equivocadas feitas no passado por países desenvolvidos que abriram mão conscientemente de suas soberanias fiscais e, ao longo do tempo, passaram a ter uma queda radical de arrecadação. Isso é uma verdade, e essa verdade se agudiza no momento de uma crise paralela a uma crise econômica que já se manifestava, e essa crise ela se torna mais difícil ainda no momento de uma pandemia internacional com consequências extremamente difíceis e pesadas para a humanidade. Essa ameaça toda ela poderia nos aproximar de uma forma mais humana e solidária. Contudo, o que a gente tem observado é um momento de incerteza, onde a gente não sabe se vai prevalecer a solidariedade social internacional ou então se essa luta tributária ela vai ser mais acirrada ainda. Os próximos tempos irão nos contar que tipo de convergência nós vamos ter. Se teremos verdadeiramente um mundo mais humano, mais solidário, e a partir disso que a gente possa visualizar uma amizade verdadeira entre os povos, ou se os países subdesenvolvidos vão continuar ainda mais subdesenvolvidos e os desenvolvidos lutando para poder segurar a sua carga tributária em patamares que aquela sociedade entenda como razoável. Agradeço muitíssimo a direção do Congresso por mais um ano estar aqui participando e fico muito contente de presidir essa mesa. Fiquei muito contente quando soube que o professor Guglielmo Maisto estaria na mesa. Lógico, estou muito feliz com todos vocês na mesa, a professora Joanna, Vikram, o Alexandre, Marta, e o Brasil está sempre aqui de braços abertos para vocês e para discutirmos esses temas interessantes. Um grande abraço a todos e um abraço a todos os participantes que nos escutam nesse momento virtualmente.